Okay, prisoners in your own land, the U.S. nigger problem. And as you analyze this screen, you see you have a depiction of North America or Almarak in, I don't know if everybody can see.
All the little out, all the little Albions with signs.
Well, not even Albion, right? See, look, all right, no seal, no flag, shadow property, political tags, reconstructed history, Christian black codes, occupation, European colonial government, usurpation of birthright and sovereignty, overthrow of de jure government, no constitution, colorable laws, colonialism. This is what's going on in North America, right? That's what that's this depiction, this satire animation. So prisoner, one who is deprived of his or her liberty and who is against his or her will, kept in confinement or custody, a person who was restrained of his or her liberty upon any action, civil or criminal, or upon commandment. So that's definition of prisoner. One who is deprived of his or her liberty, right? State property, property of the state. Are you really state property? Property of a state? Can natural flesh and blood beings be property? Answer, no. This page is an information, support, and auxiliary for those Aboriginal and Indigenous prisoners who are now and have been routinely and without lawful due processes held as captives in their own land. These colorable acts of misadministration of governmental positions are confirmed by a de facto and corrupt wardship tenure system. By the laws of nations, the laws of nations, that's a reference point. You can put that in a Google. This is a universal law. This is a law, a universal law talk terminology. By the law of nations, no state is bound to recognize slavery of another state. Reference, source of law, John Bouvier's Institutes of American Law. Section 168 of Book of Persons as well is another reference. Page 37 of that reference. Let me let somebody in here. Okay. A valid and sufficient accusatory instrument is a non-waivable jurisdictional prerequisite to a criminal prosecution. Court case People versus Case, a 1977 New York Supreme Court was actually, you see 2D, that's an abbreviation for second district. So it looks like an appellate level, this court case. All right. So why is this important? A valid and sufficient accusatory instrument is a non-waivable jurisdictional prerequisite to a criminal prosecution. So that means they must have something that's sufficient in law as an accusatory instrument. So let's put this in layman terms. What would that instrument be? An affidavit from an injured party. That's an accusatory instrument. Galaxy A112, I'm not sure who you are. Want to go ahead and introduce yourself real quick before I continue? Galaxy A112.
Yes. Can you hear me?
Yes.
This is
Yeah, that's my nephew, Mafi.
Oh, okay. Oh, Islam. Peace and love. What's your appellation? What's your title?
title. I usually call myself, I know I talk to my uncle, but I call myself African American.
No, I was saying, what's your, okay, I see how you identify.
What's
What's
your
your,
name?
what's your name?
Or black, I should say.
Yes, Alex.
Black,
What's your
okay.
name?
Oh, Arthur, I'm sorry.
Arthur, all right, it's a pleasure to meet you, Arthur.
Nice to meet you too.
Mafiel. Islam Karmisha.
Islam.
Islam, sis.
Islam, Islam.
Peace and love.
Islam.
All right,
Islam,
so
or
Islam, Jerry Blake. Islam, how you
Islam,
feeling, man?
Yes.
Islam, Jerry Blaze.
Peace.
supreme love. I'm tapped in. I'm just putting the baby to sleep, you know?
Islam.
Wow.
So far what we have is a case law, people versus case. A valid and sufficient accusatory instrument is a non-waivable jurisdictional prerequisite to a criminal prosecution. So that sufficient accusatory instrument, the root word of accusatory is accused. The instrument will be whatever the instrument is. And if it's written instrument, that means it's an affidavit of somebody accusing you. And if that's doesn't exist, then it can't be somebody accusing you of anything because nobody accused you of anything. All right, so I'm gonna continue. Nobody got questions on that. Oh shit, went crazy. The jailer is liable for the escape of prisoners lawfully in arrest, and if the arrest is illegal, he is free from all liability. He, the jailer, may therefore, in his defense, show that the court issuing the process had no jurisdiction. Reference Albee versus Ward, Massachusetts case, or that the process was void. Whereas a writ may be void because it is defective in language, because the court had no jurisdiction to issue the writ. That reference is Big Torch 122, Nixon versus Reeves. Also, you can get another reference on defective writs in Bouvier's Law Encyclopedia, Rawls, 3rd edition, revision, page 1182. The clerk of the court who issues a defective writ or one not authorized by the court is liable, and so is a judge who orders a writ which he had no right to issue or where he had no jurisdiction. Big Torch 128. Once again, Bouvier's Law Encyclopedia, Rawls, 3rd revision, page 1182. Therefore, where a copy of process was left with the jailer as his warrant, he may justify an escape by showing such copy to be on his face void. He is not bound to look beyond the copy, and the validity of the process itself is not material. Kidder versus Baker, reference point. Another reference point, John Bouvier's Institute of American Law Book of Wrongs, section 2332 on page 629. One who has been kidnapped or stolen away, or a free man who has been taken by robbers and reduced to slavery is not a slave. Reference, source of law, John Bouvier's Institute of American Law, section 165, Book of Persons, page 37. That's a reference to distinguish a free man from a slave. Abu Ar-Rahman Ibrahim ibn Sori, aka Abdul Rahman, was a prince from West Africa who was made a slave via the United States. After spending 40 years in slavery, he was freed in 1828 by order of President John Quincy Adams and Secretary of State Henry Clay after the Sultan of Morocco requested his release. He was captured near the Fota Jalan. Definition, now we're going into the definition of habeas corpus. This is a writ, habeas corpus, that all Moors are really deemed to know the function of it, especially to get, the technical filings on the record, at bare minimum, regardless of if they colonize or whatever. You want to show that it was a body of Moors that got a habeas corpus on their record if a Moor is a guy locked up and filed properly. So if things have to later in the game go to a world court for violations against the subsidiaries of the United States, we'll have exhibits. That's all we can pretty much do. So competency of a writ of habeas corpus. This writ habeas corpus is derived for the presentation of liberty to the end that no one shall detain a free person. The word free man includes every free man, infant or adult, male or female, one or many, whether sui juris or under the power of another. For we consider this is the person free. He who does not know that a free man is detained in his house is not in bad faith. But as soon as he is advised of the fact, he becomes in bad faith. Reference point of what I just read. Source of law, John Bouvier's Concise Encyclopedia of Law, Francis Rawls, 3rd edition. Revision page 1400. Definition of habeas corpus. Habeas corpus. Habeas corpus, once again, is Latin. It's a law term that's in the law dictionary. Writ of habeas corpus, writ we should know by now means command. All right, where there is entire want of jurisdiction to issue the process for not resort to an appeal. Reference, source of law, in re, Ribbon 5 Oakland 379 47 Pack 1074. John Bouvier's Concise Encyclopedia of Law, Francis Rawls, 3rd revision, page 1403, definition of habeas corpus. 2 reference points. In a false imprisonment case, the injury suffered by an individual is the illegal confinement itself, rather than any detriment occurring after the imprisonment. One who is wrongfully deprived of freedom sustains an intangible injury, the magnitude of which cannot be measured or asserted in physical terms. Although this injury may, in some cases, also cause psychological or emotional trauma. A victim of false arrest, false imprisonment, need not experience such trauma to have a legally compensatable claim. Reference point, De La Cruz versus Borough of Hillsdale, 338A, 2nd District, 498. It's a New Jersey case, appellate division, 2004 case. The infraction of personal liberty has ever been regarded as one of the greatest personal injuries. The injuries to personal liberty are malicious prosecutions or arrests and false imprisonment. Reference of what I just read, John Bouvier, Institutes of American Law, excerpts from section 2275, page 613. John Bouvier's Institute of American Law excerpt from section 203, chapter 3, page 51. Personal liberty is the independence in our actions of all other than our own. It consists in the power of locomotion, of changing situation, or removing one's person to whatever place one's inclination may direct without restraint or imprisonment. This right is protected by law. To protect the personal liberty of the citizen from unlawful arrest, it is the law that no person can be imprisoned for an alleged crime unless upon oath of some competent witness. Case law to support that. Caner versus Commonwealth. American Constitution, Amendment 4 and 5, which, if y'all don't know what that is, jot that down so y'all can know what the Fourth and the Fifth Amendment is. American Constitution, Amendment 4 and 5, and the warrant of commitment must be in writing and the hand of a competent magistrate. It must express the cause of commitment and show by what authority the prisoner is committed. Reference point, John Bouvier's Institutes of American Law, excerpts, section 210, page 51. So, Fourth Amendment, in summary, they can't search your property without a warrant. A constitutional warrant means that an indictment process took place. You were indicted, then a warrant gets issued, it's signed off on, then that warrant must be attached to an affidavit of a person that was injured. Also, the warrant needs to specify the specific place to be searched. These are all elements of what they call due process. The Fifth Amendment talks about double jeopardy, can't be tried twice, and it also talks about how you must be indicted. So I pretty much told you both just now, and how 4 and 5 together works as what they call due process. Continuing, and the warrant of commitment must be in writing. So I'm gonna move forward to the next section if nobody has questions on the first piece that I've read. Elizabeth Freeman, Mum Bet. Elizabeth Freeman, 742, December 28th, I guess she passed 829. In early life, known as Bet and later Mum Bet, was among the first Moors enslaved via Massachusetts to file a freedom suit and win in court under the 1780 Constitution, with a ruling that the slavery was illegal. So as you see, freedom suit, and we just read habeas corpus, which is basically free the body, is Latin for basically essentially free the body, and freedom suit. So stay focused on the chronological, what's trying to be expressed here. So the freedom suit and win in court under the 1780 Constitution with a ruling that slavery was illegal. Her county court case, Brom and Bet versus Ashley, decided in August 1781. The American Republic Constitution was not ratified at this time, was cited as a precedent in the Massachusetts Supreme Judicial Court appellate review of Quock Walker's freedom suit. When the Massachusetts State Supreme Court upheld Walker's freedom under the Constitution, the ruling was considered to have implicitly ended slavery for the state of Massachusetts. So res judicata on the books. Basically, this is basically another Sundry Free Moors Act. Basically, because it's basically stating how a free man was released based on they not slaves status, essentially. Everybody here should know about the Sundry Free Moors Act. I would imagine. If not, please let me know. Razir Islam and the other brother, I don't want to butcher your name, Rahul something.
Islam.
Islam, Morris. Peace, peace, peace,
Islam, Noble.
peace and love, Morris. Peace and love, nobility.
Islam.
Islam.
Oh yeah, Islam, Razi Leon, Islam.
Islam.
All right, so we got any questions before I move forward? All right.
You said it was the Free Moors Act.
Sundry Free Moors Act. So that's
Hundry.
SUNDRY, sundry.
Oh, Sundry Free
Yes.
Moors Act. All right.
Yeah. And sundry means various. All right. Oh, of 1790, Sundry Free Moors Act of 1790. That'll help your Google search or whatnot. Okay. Robert Lumpkin's slave jail was known as the Devil's Half Acre, located on American territory of which is called, in a quasi-fashion, Richmond, Virginia. Richmond, Virginia was the nerve center for so-called slave trading, which in fact and truth is human trafficking, and boasted as the largest running operation outside of so-called New Orleans. Robert Lumpkin made a transaction for approximately $6,000 November 27th, 1844, Gregorian calendar, to acquire an establishment of which was already in operation as a holding facility for so-called slaves. However, when Robert Lumpkin took possession, the extremities of the reestablishment increased. There were 4 other lots on what was called Wall Street, which is now called 15th Street, that contained what they call slave jails. The area was collectively called Lumpkin's Alley. The jail was situated along Shockoe Creek and featured barred windows, high fences, chain gate openings to rutted streets. I will omit details of the other extremities, leaving it to the reader to research. However, I trust the reader can imagine the conditions of being kidnapped and placed with a multitude of people with no bathroom and no access to the outside world except through a small window. So named Anthony Burns. A portrait of the so-called fugitive slave, Anthony Burns, whose arrests and trial under the Fugitive Slave Act of 1850. The Fugitive Slave Act of 1850 touched off riots and protests by abolitionists and citizens of Boston in the spring of 1854 Gregorian calendar. A bust portrait of the 24-year-old so named Burns, drawn by Barry from a daguerreotype by Whipple and Black, is surrounded by scenes from his life. Burns was a captive in Lumpkin's jail. At the age of 19 in 1853, he escaped slavery from Richmond, traveling by ship to Boston in the free state of Massachusetts. In Boston, he worked for a pie company and for a man named Coffin Pitts, a clothing dealer on number 36 Brattle Street. President Franklin Pierce was determined to turn over a so-called escaped slave. He set his sight on turning over the Moor called Anthony Burns from Boston, a center of abolitionist activity, to quasi-national Virginia in order to show Southern politicians that Northern quasi-national domiciles would enforce the Fugitive Slave Act, a key provision of the Compromise of 1850. That's very interesting. Very, very interesting right there. However, all Europeans were not for slavery, quote unquote, whereas the Fugitive Act or the Fugitive Slave Act was fiercely resisted near Boston. The Anthony Burns case attracted national publicity, large demonstrations, protests, and an attack on U.S. Marshals at the courthouse. So named Anthony Burns was basically kidnapped near Boston while walking down Court Street. Some abolitionists were outraged due to the enforcement of the unlawful, unconstitutional Fugitive Slave Act of 1850. On May 26, 1854, before so-called Burns court case near Boston, a crowd of both Moors and Europeans, including Thomas Wentworth Higgins and others, stormed the courthouse to free so-named Burns. Moors and Europeans' efforts were in conjunction. Are y'all hearing this? They stormed the courthouse and got them out of jail themselves because it was so deep. In the midst of the attempt of Moors and Europeans to free Burns, the deputy U.S. Marshal named James Batchelor was fatally stabbed. James Batchelor was the second U.S. Marshal to be expired in the so-called line of duty. A grand jury indicted 3 of those involved with the attack of that courthouse. After an acquittal of 1 man and several hung juries and trials for the others, the federal government dropped the charges. Reference point of what I just read, Stephen E. Barkan, October 1983. Jury nullification and political trials, 31 subsection 1. Social problems, page 28 through 44, second reference point. Where a person who is not vested by law with authority to make an arrest attempts to do so, he acts as a private citizen, and one who opposes him therein is not guilty of opposing an officer. Case law, U.S. versus Baird, federal court case. Second reference point, John Bouvier's Concise Encyclopedia of Law, Francis Rouse, third revision, page 2397. The right of self-defense extends to injuries committed against the limbs and the body of man, and the aggressor may even be killed if the person attacked has no other means of saving himself. Reference, source of law, John Bouvier's Institute of American Law, excerpt, section 204, page 50. The accused may demur. Nobody knows what demur is? Look up what demur is. Law terms. The accused may demur to the complaint when it shall appear upon the face thereof, either as follows. So I'm about to run off 6 things. If the accused may demur to the complaint when these 6 things I'm about to read shall appear on the face of the complaint. 1, that the court has no jurisdiction of the person of the defendant / accused or of the subject of the action. Or 2, the plaintiff has no legal capacity to sue, which means they're a minor, right, or minority status. Or 3, there is another cause of action pending between the same parties for the same cause. Or 4, there is a defect of parties, plaintiff or defendant, emphasis on the nom de guerre. Or 5, several causes of action have been improperly united. Or 6, the complaint does not state facts sufficient to constitute a cause of action. Reference, source of law, John Bouvier's Institute of American Law, section 3270, subsection 144, subsection 122. Prisoner in their own land. A prisoner is one who is deprived of his or her liberty and who is against his or her will, kept in confinement or custody. A person who is restrained of his or her liberty upon any action, civil or criminal, or upon commandment. Government. To govern means to direct and control the actions or the conduct of people or things, either by established laws or by arbitrary will. Thus, the authorities and authorizations used or claimed by persons in government, you should always be put to question of legitimacy or illegitimacy. Always consider whether or not an action taken or initiated by an alleged representative or personnel in government is confirmed by due process. Is confirmed by due process. And we just went over that. 4th and 5th Amendment, collectively. equals due process under the law and measured by the supreme law of the land. The supreme law of the land is the Constitution for the United States Republic of North America. The governmental principles that underscore and give life to this foundation instrument of law are ancient in their origin, coming down from principles of jurisprudence as taught by the Moorish sovereigns of the Old World. Government is derived from the Old Moorish Latin word vernaculium. The science that treats of positive law is known as jurisprudence. Jurisprudence is the philosophy of law, or the science that treats of positive law and of legal relations. So when you look up positive law, that's a thing. It's positive law. Look, put that in a Google search. It's going to show you what that is. And of legal relations. Jurisprudence is a term that does not apply directly to the systems of law, or to current views of law, or to suggestions for amendments to law. Jurisprudence is, however, the name of a science, being formal or analytical, rather than a material one. It is the science of actual or positive law. Misprison in government. Any questions before I move on to this next piece?
No, but I want to say wow.
Yeah, wowzers. Misprison in government. Referencing the contemporary governments in the United States of North America, the predominant number of politicians, administrators, wardens, law officers, and policymen operating in the United States of America are European colonial descendants. This obvious imbalance of personnel in North American states, governments is strongly reflected on all levels, the federal, the states, and the municipalities. This biased social design is falsely propagated as racism. However, racism professed for misdirection purposes is a public facade and cover-up. The true motives, or Morris Latin, modus operandi, are actually their commonly practiced inter caetera divina, church bulla culture, allegiances, and influences. This decree is the latter of two Inquisition church bullas or bulls issued during 1492 and 1493 AD. Now that the commonly recognized untoward and antisocial actions and attitudes being marked social, signatures of Europeans in America are not mere acts of what has been traditionally and falsely tagged as prejudice. Europeans occupying North America are religiously dedicated to their Inter Caetera Divina, church bulla. Inter Caetera Divina is the true secretive guide source for their social engineering protocols, used to amass wealth from aboriginals by direct theft, trickery, adhesion contracts, and color of law. This bulla is the source of their lack of moral conscience, rooted in their religious foundation. These and related policies are applied against all Aboriginal natural people held under a U.S. de facto government. Consequently, their practiced color of law, color of authority, and color of office legal processes often contradict due process, constitutional principles. These disparaging and deviant administrative performances are obviously reflected in the prisons and jails, being veiled concentration camps in North America. Though very few would speak openly about these bullas, this is the eventual truth as to why Asiatics, Aboriginals, fill the prisons and jails in such unfair and irrefutable high numbers. To support the economic demands of the church bullas, the de facto court system operatives constantly violate Constitution secure laws, see Article 6 of the Constitution, and commit numerous transgressions against natural peoples, rights, and immunities, while knowingly violating international law. So let me stop this recording.